Um, Hello, everyone. I'm Carol Lee Smith. I'm a lawyer in Toronto and co-chair of the FASD Justice Committee. I'm here with our presenters, Dr. Caitlin McLaughlin, Caitlin Mullally, and Jonathan Rudin. And on behalf of the FASD Justice Committee and our presenters, I welcome you all to the third webinar in our series, FASD and the Justice System, A Better Understanding. And today we're going to talk about evidence in criminal law. So we know we have people joining us for the live session today from across Canada and the US, from New Zealand, across the world. And before we begin, we want to acknowledge that these places where we are, lands that we're on, have been the home and traditional territory of Indigenous peoples for many thousands of years. And we're grateful to be living, working, and learning in our communities on these lands. So our presenters today are going to talk about their recent in-depth study of FASD evidence in Canadian criminal cases, which is a systematic review of reported criminal cases across the country between 2012 and 2020. The paper documenting their findings was recently published in the American Psychological Association journal, Psychology, Public Policy, and Law. And we're going to share a link to the study as we go. And here today, they're going to share details about the study, some insight from their findings, and some critical observations about their research. So we're welcome questions, and we'll get to as many as we can. I'll be watching the Q&A for your questions as we go, and we'll allow the time for panelists to respond at the end when they have finished their presentation. So please use the Q&A function at the bottom of your screen to ask your questions. And if you see a question that someone else is asking and you also would like to hear the panelists comment on, use the polling function to vote for it. The webinar is being recorded and will be posted to the website fasdjustice.ca. We're going to use some slides, as you can see, as the presentation goes forward. And the slides will also be available on the website following the webinar today. So now it is my great pleasure to introduce our panelists. Dr. Caitlin McLaughlin is Associate Professor and Director of the Psychology, Law, and Neurodevelopment Research and Policy Group at the University of Guelph in Ontario. She is also the Research Lead in Justice for Canada FASD Research Network. And Caitlin Mullally is a PhD student in the Psychology, Law, and Neurodevelopment Research and Policy Group in Guelph. Jonathan Rudin is Special Projects Director, at Aboriginal Legal Services based in Toronto and co-chair with me of the FASD Justice Committee. Jonathan is also the author of Indigenous People and the Criminal Justice System. So thank you so much, all of you, for being here. And I will turn it over to Caitlin McLaughlin, who's going to start us off.
Thanks very much for that very warm welcome, and welcome to everyone joining us from near and far. I got a peek at the participant list and got to see colleagues, collaborators, folks who I knew are doing really tremendous work in this field, and lots of new names and faces too. So please join us in a warm welcome. Caitlin and I will be referring not to ourselves in the third person, but there are indeed two Caitlins, and Caitlin is controlling these slides. So occasionally, if I ask myself to move the slides along, rest assured that I'm doing well and just making sure that the deck goes through. So Caitlin, we'll get started on the slides. And as we begin our presentation, I did want to indicate that for today, at least, this paper is available and free to access online, as it was a featured paper and the American Psychological Association has made it free to access. We'll pop that link in the chat. And then I'm sure when that paywall drops again, it's also archived on the University of Guelph open access website. For folks who are interested in grabbing it later, feel free to be in touch. This research has been a labor of love and a lot of effort. It was the very first project we began in our research group after I moved to the University of Guelph, and there are far too many people to acknowledge in this short time. But I really do want to acknowledge all of the volunteers and undergraduate and graduate students who are part of the Plan Lab research team who contributed their time combing through these legal decisions and carefully coding all of the content of so many cases and really scrupulously. I really would like to acknowledge the profoundly sad and unexpected loss of our collaborator and co-author, Dr. Jody Fillion, who was a really important mentor for me in my professional and personal life, and really was inspirational in the way that we approached this work. So I had personally dedicated this paper to her. And I'd like to thank Dr. Billy Joe Rogers for her supportive and really thoughtful, critical review of our paper, providing input around cultural safety, just given how important some of the themes are that come through this work, and funding from the Canada FASD Research Network. So here we go. Before we launch into our findings, I'm just going to share a little bit of background, assuming that not everybody is an expert on FASD in the criminal legal system. So FASD is a diagnostic term in Canada that's used to describe the broad-ranging and variable neurodevelopmental impacts on the brain and body of individuals who are exposed to alcohol prenatally. Folks with fetal alcohol spectrum disorder can experience variable impacts across the lifespan, though these can change over time and present in different ways at different developmental stages. And there is lots of variability between folks with FASD, just like everyone. No two people with FASD are alike, and none of us are the same from day to day. And that's true also for people with FASD. Most people with FASD will experience some degree of challenges in their daily living and need support to reach their full potential, but with the right kinds of supports and recognition, really thrive and have all kinds of meaningful and healthy outcomes. Um, we'll move to the next slide. Um, oh, sorry, Caitlin, go back one. You jumped ahead and I'm driving. So people with FASD, like everyone, have a whole array of strengths and unique areas of challenges. Some of the challenges that are relevant for consideration in criminal legal contexts include overall intellectual functioning, differences in brain functioning across areas like executive functioning and attention, language and communication, memory, the way that they relate to others from a psychosocial perspective, the way that they control their decisions and sort of make decisions on the spur of the moment, and sometimes having difficulties making their best decisions on the spur of the moment and being able to really have access to cause and effect reasoning at any given point in time. And like everyone, folks with FASD have all kinds of incredible strengths, and there's an important and emerging literature that is emphasizing the need to balance out a strengths-based perspective on people with FASD, including those who become involved in the criminal legal system, with research showing all kinds of strengths like strong self-awareness, receptivity to support, capacity for connection with others, perseverance, and hope for the future. And many of these strengths and protective factors are linked with, again, when supported, really great outcomes navigating the criminal legal system. In terms of prevalence, FASD is a common neurodevelopmental disability. Research is still mixed, and conservative estimates suggest that that rate in Canada may fall anywhere between 2 and 5%. If you take a 4% estimate in the middle, that would be 4 in 100 people, or roughly 1.45 million people in Canada. And a small number of studies conducted in Canada and the United States that look at folks who have accessed FASD diagnostic services have found much higher rates of criminal legal system involvement or contact amongst folks accessing those diagnostic services, with estimates suggesting that between 1 and 2/3 of folks may have come into contact with the criminal legal system. The overall estimated lifetime costs per person in Canada associated with FASD are thought to be quite high, and criminal legal system drivers form amongst the top contributors to some of those costs. And some of this we think is owing to the very, very high rates of missed and misdiagnosis. not being able to recognize, particularly at an early stage, that somebody may have had PAE and may have FASD, not recognizing that really renders us unable to fully understand their unique profile of needs and strengths, and thus provide tailored interventions and supports across the lifetime. We'll head to the next one, Caitlin. Just a couple of key messages before we dive into the criminal legal system focus. Early identification and tailored interventions really can support leveraging strengths and help individuals achieve healthy outcomes. And we know from research that these factors can play a really important protective role in buffering against difficulties. That being said, while many people with FASD experience higher rates of difficulties when not appropriately understood and supported, there remains really wide variability in the pathways, trajectories, experiences, and patterns of needs that people with FASD experience. And so there is absolutely no foregone conclusion that someone with FASD will experience contact with the criminal legal system. And this quote from my colleague, Dr. Katie Flanagan, helps sum up an important reminder that FASD in and of itself, there's nothing about FASD or the diagnosis that results in any kind of trajectory associated with criminality, but may serve as a marker of an increased cluster of risk factors that together, when combined and not appropriately supported, can result in engagement in the criminal justice system. So I mentioned in the general population, estimates ranging anywhere from 2 to 5%, thinking that these are conservative. But when we look at the small number of studies that have been conducted in small sample, single site forensic and correctional settings, often samples include no more than 100 or 200 folks, where they've tried to estimate rates of FASD in a single setting. The emerging evidence suggests that folks with FASD are much overrepresented in these contexts, with studies internationally that include adolescents and adults showing anywhere from 10 to as high as 46% of people who were assessed ending up meeting diagnostic criteria. So these rates, combined with those rates of contact we're seeing in clinical settings, are compelling us to recognize that there are elevated experiences of criminal legal system experience for folks with FASD, and also higher rates of folks with FASD in criminal legal settings in Canada and in other jurisdictions around the world. This now brings us to our research and to our early thinking as a lab that really focuses on trying to understand evidence to inform policy and appropriate intervention and support services. A number of studies, including case law reviews, show us that FASD is being increasingly considered as evidence across a range of legal matters. Data from legal reviews, clinical reviews, case law reviews show us that FASD has been found to have relevance at all kinds of adjudicative stages, including thinking about rights waiver at arrest and statement validity, plea decisions, sentencing, determinations of guilt, determination of dangerous or long-term offender designations, matters related to competency and criminal responsibility, and the list goes on. And some experts have suggested that FASD in and of itself and the kinds of needs and experiences that folks with FASD commonly experience may in and of itself challenge some of the fundamental assumptions of the criminal legal system, with examples including the assumption that people make voluntary and informed choices, that knowing consequences will be able to deter future behavior and shape the kinds of decisions that people are making in the spur of the moment, and that any departures from these assumptions are momentary and can be corrected. So these are some real challenges that folks with FASD and lots of other neurodevelopmental disabilities and mental health needs may really not fall into line with some of those fundamental assumptions of the way our criminal legal system operates in Canada and in other common law adversarial jurisdictions. And bringing all of this information together, efforts have begun to mount recognizing the challenges that folks with FASD present and this overrepresentation and unmet needs, resulting in all kinds of policy-based proposals, including legislative reform, attempting to increase awareness, recognition, and appropriate response to the needs of people with FASD in the criminal legal system. And some of these bills have passed around the world, and others in Canada in particular have not. But we really feel that it's important to understand the potential impact of FASD evidence, which would be likely raised at more often in criminal legal cases should these bills and types of legislative reforms pass. It's really important to understand what that increased exposure of FASD evidence would have on legal decision making and case outcomes to ensure that these kinds of reform efforts are evidence informed. So there, as an emerging body of literature with case law reviews conducted case by case in a couple of international jurisdictions, more systematically in the US and in Canada, many reviews have tried to look at the impact of evidence about FASD on criminal legal decisions. And in general, these findings have suggested that FASD and evidence about prenatal alcohol exposure is often discussed without the presence of a formal diagnostic assessment or the aid of an expert in being able to convey important information about the FASD evidence that's being raised. And increasingly, analyses have shown this grappling with FASD as sort of a double-edged sword, as Dr. Jennifer Chandler spoke about in her case law review published now several years ago, where on the one hand, evidence about FASD may be seen as reducing moral blameworthiness, but at the same time, and sometimes more subtly, simultaneously increasing perceptions about risk, dangerousness, and pessimism for rehabilitation, particularly in the case of very serious violent offenses. And despite this emerging literature, some gaps remain. Lots of these reviews of cases have involved smaller samples, were published now many years ago, or have focused on discrete kinds of offense patterns or published legal decisions. And so ultimately, the aim of our paper was to look at a much longer and broader sample of Canadian criminal legal decisions that were published. So we're looking only at publicly published and available reasons for decisions between 2012 and 2020, where evidence about FASD or prenatal alcohol exposure was mentioned, specifically in relation to the defendant. And throughout the rest of our presentation, we use the term FASD to talk about evidence related to FASD or prenatal alcohol exposure, but acknowledge that sometimes the actual wording used in a case decision may have been one or the other. And so at this point, I'm going to turn it over to Caitlin to talk about some of our methods and findings.
Right. Hello, everybody. So I'll start by just sharing a brief overview of our study method before jumping into the really exciting parts about our results. Make sure. Okay. So for the study, we started with by conducting a systematic search of two Canadian legal databases, so CanLII and Westlaw, using these structured search terms on my screen here. In doing this, we initially, and as Caitlin mentioned, we looked at cases from 2012 to May 2020, so just those first couple of months of 2020. So using this approach, we initially came across just over 1,000 cases. We went through a process of screening for duplicates, assessing cases for eligibility, and we ultimately ended up with a sample of 350 cases, which we then coded using a structured coding form and content analysis. And just briefly, the coding form was developed by our research team based on some of those prior FASD and mental health case law reviews that Caitlin mentioned. And it included a range of variables, many of which we'll touch on today. So we looked at things encoded for defendant characteristics, statements about FASD or PAE, clinical FASD evaluations, GLADU considerations, and other legal and clinical considerations, and then case outcomes as well. Okay, so our study results. So just briefly starting with an overview of those 350 cases. So this figure here shows the jurisdiction and then the year of the decisions. So where darker blue on this map of Canada here indicates a greater number of cases. So you can see We have a large number of cases from Western provinces and territories, which Jonathan, I think, will talk more about later on. They were relatively across these years, relatively evenly distributed over time. And I just note a few less in 2020 because we only looked at a couple of months into 2020. The cases included in our sample were primarily drawn from adult criminal court. The large majority of them involved a male defendant. I note here, so defendant ethnicity was disproportionately identified as Indigenous, and so in 77% of cases, it was noted that the defendant was Indigenous. And in the large majority, so 22% of those remaining cases, the defendant's ethnicity was not clearly stated or mentioned. And again, we'll talk about this in some more detail, but I wanted to make the point here as well, given its importance, as we really situate these findings in the context of ongoing colonization, assimilationist government policies, systemic racism, and adverse intergenerational impacts, as well as specialized sentencing provisions in Canada for Indigenous defendants. In terms of the type of cases and decisions, so you can see on the right here, sentencing decisions were most common, with the majority being initial decisions, but a small number of cases across the board here, again, which I'll go through in a bit more detail. In terms of how FASD was discussed or presented, so we first looked at the number of times FASD was mentioned throughout the legal decision. And just briefly, I'll note that we defined a mention as 1 to 3 consecutive sentences discussing or mentioning FASD. So it wasn't necessarily the number of times the term appeared in the paper. You can see this varied substantially, though many cases, so just under half of cases mentioned FASD only once, so sort of briefly in passing, and then moved on. FASD had been formally diagnosed in just over half of the cases in our sample. So this here is about 53% of cases, the remainder of which mentioned either possible FASD without a formal diagnosis, or there was unclear diagnostic status. It wasn't clear whether they had actually been diagnosed or not. Few cases mentioned or referenced a formal FASD assessment. So this top piece up here, most of which had occurred at some point in the past. So rather than being undertaken or requested in the context of the current adjudication, though some mentioned both a current assessment and a historical assessment. So we started by looking at the 350 cases, and then we coded those cases for what we called relevance across 4 categories. And I've included here what those 4 categories are and our definition. So this ranged from no relevance to what we termed great relevance. And this coding, as you can see here, was based on the number of times that FASD was mentioned in the decisions, but also whether or how it was connected to legally relevant factors in the actual decision or analysis. So you can see here, no relevance were those cases where FASD was mentioned briefly, often just once. It wasn't connected with any legal decisions or key aspects of legal decision making, whereas those great relevance cases, by definition, often included more mention of FASD. But importantly, in these cases, FASD was directly connected to legally relevant factors in the decision or analysis. So for example, it being connected to sentencing principles or goals of sentencing. So you'll see here 76 of the cases in our sample, so just under 1/5 of cases were deemed to have great relevance based on this criteria. The large majority of those were sentencing decisions or sentencing cases, so 67 of those, though there were a small number of DO-LTO, guilt, innocence, and NCR cases that were deemed to have great relevance, which I'll talk about as well. So our results really focus on those sentencing decisions, given they made up the large majority of our sample of great relevance cases. So I'll start by talking about those. And I think starting with a broad picture, within these sentencing cases with great relevance, we saw that judges often considered FASD evidence in the context of balancing key goals and principles of sentencing. And many also reflected and really discussed the challenge of applying FASD evidence appropriately in these cases and making sentencing decisions, particularly following serious crimes, given some of those tensions that Caitlin mentioned that we also saw in our data set here. So going through sort of each of these themes that emerged from the data. So FASD evidence was often discussed in the context of proportionality. And in most discussions, there was comments that FASD may reduce a defendant's degree of responsibility or moral blameworthiness, with note or the caveat that this must be balanced, of course, with protection of the public and may be outweighed by the gravity of the offense, particularly in cases involving really serious violent crimes. And I'll note as well, in some cases, judges explicitly noted that application of these principles is not automatic in cases involving a defendant with FASD and is really dependent on the severity of challenges associated with the disability and must be considered on a case-by-case basis. FASD was often discussed as well in the context of mitigation. And in these cases, FASD was actually generally accepted as a mitigating factor. And I've included some quotes from the cases where relevant. So in this case, for example, it was noted explicitly, the law is now clear that FASD is a disorder that can be a mitigating circumstance. Many discussions within these cases focused on balancing fit sentences for defendants with FASD in the context of considerations of risk and public safety and separation. And I'll note these discussions or sort of opinions on this were mixed. So some said that public protection is less relevant in cases involving a defendant with FASD and must really be balanced with considerations of reduced moral blameworthiness. Though others noted that FASD can increase risk, and they really emphasize the importance of public safety and separation in these cases. And so I've included a quote here. It's quite long, but just to summarize, the case noted that circumstances, so mental disabilities or illnesses such as FASD, can be significant mitigating factors, but it goes on to note, however, where mental illness or disability creates a risk to the safety of others, these circumstances can turn into aggravating factors and may require that the individual be separated from society. Within these cases, judges also frequently weighed rehabilitative considerations, both as a goal of sentencing and then generally in the context of perceptions about treatability or an offender's opportunity to be rehabilitated. So in some cases, it was noted and rehabilitation was really emphasized as a priority for defendants with FASD, with an emphasis on the need for intensive community-based supervision and support for these individuals. In others, though, there was debate about whether rehabilitation was possible for individuals with FASD due to its lifelong nature. And so I've included a quote here where it notes, rehabilitation as it is conventionally understood is largely a cognitive process premised on the ability to understand, to learn, to remember, and to make choices. And none of these assumptions fit well with what is known about FASD, a permanent form of brain damage that can affect all parts of the brain. However, some cases mention the need to move away from these traditional views of rehabilitation that really stress the removal of symptoms or behaviors towards an emphasis or a greater emphasis on management. So as an example, in one case, it was noted, rehabilitation is not limited to the traditional view of correcting the accused's attitude to prevent him from recidivating. It can also deal with finding a way to control and modify the behavior. And I'll also note now as well, in some of these cases, there were concerns identified about available rehabilitation options for defendants with FASD. So this idea that outside of the criminal legal system, if this individual were to return to the community, that there is a limited number or complete lack of appropriate supports available to them in the community, which can result in this idea of incarceration by default. FASD was also often discussed in relation to deterrence and denunciation, and often together. So there was general agreement within these cases that both are less relevant in the context of a defendant with FASD, given that FASD challenges their underlying assumptions. And Caitlin spoke a bit about this as well. This idea, right, that these principles sort of assume that an individual can restrain impulses and can understand the link between behavior and consequences and make decisions accordingly. And in some cases, it was actually noted more specifically that incarceration as a whole may be less effective for individuals with FASD, given this idea, or given these challenges they may experience. So I think worth mentioning as well, although there were just a smaller number of cases that fell within this sort of category, but of note, some judges indicated that they didn't have enough information about FASD to inform their decisions. And so they really were asking for or highlighted the need for further FASD assessments or further medical evidence to support decision-making in these cases, and that they were really limited in their ability to consider this evidence without additional information or context about that defendant's disability and their unique strengths and challenges. FASD was also often discussed in the context of GLADU considerations. So this was in about half of those sentencing cases with great relevance, so 28 of those cases. And the way that FASD was brought up or mentioned in these cases varied a little bit. So in some cases, FASD was explicitly identified as a GLADU factor. In other cases, it was more generally sort of brought forward in the context of a GLADU report, but not identified as a GLADU factor specifically. And then in others, it was sort of just broadly intertwined with consideration or discussion of GLADU factors or a defendant's Indigenous background. And in these cases, several judges noted that FASD and GLADU factors are sort of inextricably linked. So specifically that substance use difficulties in FASD can sometimes be understood, right, in the context, as I mentioned before, of colonization and residential schools in Canada and systemic racism and the associated intergenerational impacts on Indigenous people. And some decisions clearly discussed this connection. So as in the case I've included here, the quote I've included here, they clearly note the defendant's GLADU factors are in many regards intertwined with his cognitive deficits. And they go on to say that sort of taken together, these factors clearly reduce the defendant's moral blameworthiness. And I think this is really important to note, to highlight this connection so as not to perpetuate harmful and erroneous perceptions about FASD and indigeneity, or to reinforce perceptions or to place blame on biological mothers. So I think being very thoughtful about how these ideas are presented and discussed in this context. And that there were some cases where this connection wasn't made as clear. This was sort of mentioned in passing without this additional context, which we think is really important to highlight. So FASD evidence also had great relevance in a small number of youth sentencing cases. So there were 13 youth cases where FASD had great relevance. So in these cases, we wanted to look at whether FASD evidence was specifically connected to any factors that are unique to youth defendants. And we saw a couple of examples of this. So we often saw that FASD evidence was connected to or discussed in the context of considerations about adult sentencing and placement considerations. So there was question about which would offer the most appropriate programming for a youth with FASD, the youth system or the adult system. And I'll note that decisions around this or opinions on this varied. There was also discussion in these cases about which avenue was safest for youth with FASD. And there was concern about them being victimized within the adult system due to their increased vulnerability given their young age and their neurodevelopmental challenges. And then in some cases, judges referred to this idea that we also often refer to in the literature as double jeopardy, experienced by youth due to the combined impact of their young age and associated developmental considerations and their disability and associated neurodevelopmental challenges, which together was noted can contribute to considerations of diminished blameworthiness. So in addition to coding cases for great relevance or for relevance, we also coded cases for impact. And we defined this as cases where FASD was clearly linked to the judge's actual legal decision. So not just considerations, but the actual outcome of the case. And so in these sentencing cases with great relevance, we found 12 cases where FASD seemed to have a clear impact on the ultimate legal outcome. And the impact in these cases were variable. So FASD sometimes seemed to result in reduced sentencing durations, application of non-custodial sentencing options to minimize the negative impact of jail time on these individuals, increased credit for time served in pretrial custody, and specialized placement or sentencing conditions to meet the defendant's unique needs given their disability or other considerations. So I focused a lot on sentencing cases, but I also noted as well, and I think certainly worth jumping into and discussing is those other cases that we had where FASD had great relevance. So I'll go through each of those here and just a little bit about what those discussions about FASD evidence looked like in these cases. So starting with dangerous offender or long-term offender designation cases. So FASD evidence had FASD had great relevance in 3 of the 40 DO LTO cases in our sample, so just over 7%. In these cases, FASD was often mentioned or sort of brought forward in the context of court-ordered forensic assessments, and it was often linked to, similar to sentencing cases, linked to discussions and considerations around risk and dangerousness. And so I've included just a brief quote, or not a brief quote, sorry, a long quote here of what this looked like or what discussions around this looked like. So sort of connecting this idea, FASD, to sort of the trajectory of this defendant's sort of antisocial behavior and offending, and that taken together, these factors, the permanence of FASD, substance use difficulties, and potential contact with victims who remain at a high risk for reoffending. And I'll note, so of these 3 DO LTO cases, FASD didn't seem to have a clear impact on case outcomes in any of them. FASD also had great relevance in 2 of the 12 cases in our sample involving determinations of guilt or innocence. And in both cases, FASD was considered or discussed in relation to the credibility of the defendant and their testimony. So in one case, the defendant was considered to be sort of a difficult witness due to self-disclosed memory difficulties associated with FASD, as well as his general lack of insight or understanding into the offense. And in another, which actually involved a youth defendant who had difficulty recalling the details of the events, which was attributed both to his FASD as well as a learning disability and substance use. And his testimony was determined to be too vague and was dismissed as a result. And then finally, FASD had great relevance in 2 of the 3 NCR cases in our sample. And I note here I've included this map again on this slide because I wanted to highlight that both of these cases were decided in the Yukon. So in both of these cases, FASD was clearly identified as having met criteria for a mental disorder or disease of the mind based on the legal criteria. And both of these defendants were found to be not criminally responsible by reason of mental disorder. And I'll note that these decisions seem to be quite a departure from predominant jurisprudence concerning FASD and the NCR defense. And actually, in one of these cases, the judge noted explicitly that this decision was not meant to establish a new legal framework or precedent with respect to FASD and NCR. And I point out the location where these cases were decided, just given the importance, I think, of considering jurisdictional differences in resources and practices that might impact these kinds of legal decisions and dispositions, which we can certainly talk more about at the end. And I'll note here as well, so we did have a couple of cases in our sample focused on fitness to stand trial. FASD did not have great relevance in either of those two cases, so we didn't sort of dive into those further and haven't discussed them further here. Okay, and I will pass it back to you, Caitlin, for our discussion.
Thanks, Caitlin. Other Caitlin, second Caitlin, first Caitlin. Terrific. You can move over to the next slide. Perfect. So just to kind of summarize some of the key findings from this paper, like other reviews of published case law decisions in Canada and in other places around the world, we found really substantial variability in terms of the nature of how FASD evidence was introduced across cases. And that overall, often FASD was mentioned very briefly, was not sort of connected with great relevance to ultimately the emphasized reasons for legal decisions in the written decision, and mentions were often brief. So there was a lot of variability, and in nearly half the cases, 40-some%, FASD or evidence about FASD or PAE was really only mentioned once. And so that sort of prompted us to think a little bit about why might some of these mentions be coming up so infrequently. It may be in part due to what we know is growing recognition, but still limited knowledge and awareness about FASD amongst a range of legal professionals and also amongst forensic clinicians who may be completing mental health assessments, particularly for youth or for adults before the courts. We know from evidence that forensic mental health clinicians still have limited knowledge about FASD and feel ill-equipped in general to do diagnostic assessments and to provide risk recommendations and interventions. So that's a really important growing area of need. There are also clear assessments in Canada and clear limitations in Canada and elsewhere around the world in terms of people being able to access evidence-based screening approaches and a hugely limited number of specialized diagnostic service opportunities for folks to actually complete a diagnostic assessment and understand whether they may have FASD. This is especially complex and limited for adults, where in Canada, there are fewer funded pathways to access diagnostic assessments, particularly for people before the courts, and also fewer opportunities for people before the courts as opposed to clinical availability in everyday community settings. And the funding corridors are very narrow to understand who would be able to fund these kinds of diagnostic assessments. Even if somebody wanted to access a diagnostic assessment and was considering presenting evidence about FASD, I think there still remain really serious and valid concerns about incorrect facts and negative stigma and stereotypes about FASD that may actually be harmful ultimately, whether overtly or more indirectly to someone's case or defense, particularly when there's not an opportunity to have up-to-date evidence-based destigmatizing information presented on that individual's behalf. Across lots of decisions, we heard more outdated perceptions of FASD as being a completely untreatable or permanent neurodevelopmental disability. And those myths are certainly lifting, with lots of opportunity for growth and change for people with FASD when understood and provided with effective wraparound services and supports that are tailored to that individual's needs. As Caitlin mentioned, I think the courts are really also grappling with a really limited number of community-based options to support the sometimes complex and multifold needs of youth and adults with FASD who find themselves involved in the criminal legal system, often forcing courts to think more about longer term correctional placements because of a lack of resources. And so that's a really important implication of these findings. It's difficult to consider information about FASD overall when there's not a diagnosis, there's limited information about it and its implications, and no supports available to actually provide the kinds of safe community placements that would ultimately support healthy outcomes and mitigate risk. So you can head on to the next slide there for me, Caitlin. Thank you. I think across our review and generally, there's emerging consensus that FASD is recognized as a mitigating factor that can reduce a defendant's responsibility and moral culpability, with a combined de-emphasis on some key sentencing goals like denunciation and deterrence. Again, like Caitlin mentioned earlier, though, notwithstanding this really requiring a case-by-case individualized assessment of relevant needs and deficits for each defendant. And that caveat's problematic when we see so few opportunities for people to actually access an up-to-date and timely evidence-based FASD diagnostic assessment, particularly when we think about sometimes how quickly, relatively quickly, matters may move through the courts. Ultimately, like previous reviews have found, the courts and judges are continuing to grapple with competing considerations, where on the one hand, as Caitlin mentioned earlier, FASD may be seen as mitigating. We often saw extensive discussions around reduced blameworthiness and highlighting the important emphasis and need for rehabilitation and support. But that those discussions were frequently balanced around concerns for increased risk, the need for public protection, and sometimes pessimism for rehabilitation. And sometimes that was coming from evidence from risk assessments, but again, complicated by a lack of overall clinical information and very few experts able to speak to sort of the link between clinical findings about an FASD diagnostic assessment and forensic assessments, really helping the court understand the connection between that clinical information and how it might be relevant in different kinds of forensic and legally relevant matters. And so together, taking into consideration all of these findings, these tables are big, but I knew the slides were going to be online and they're certainly available in the paper. We just wanted to highlight a few key areas that we think require additional attention, funding, resource support, and policy development. Overall, these findings really speak to a continued need for improved recognition and understanding of people with FASD, including adolescents and adults who find themselves involved in the criminal legal system and before the courts. And this might look like enhanced systematic screening practices and identification practices in community and adjudicative and correctional based contexts, as well as determining how to best increase the availability of access to assessments that are comprehensive, that include consideration of FASD, but also all of the other kinds of factors that are so relevant to consider in being able to shape and craft an effective sentence to guide legal decisions. We think it's really important that these evaluations should be as current as possible because people change over the lifetime, and an assessment from when they were 5 in a community pediatric clinic is really not going to have the relevant information about a person's current functioning and needs at age 17 or at age 30, and that these assessments ideally would be completed by experts with opportunities for some of that discussion and communication with the court via experts who can speak to both the clinically and forensically relevant factors. When thinking about screening and increasing access to diagnostic assessment, we think it's really important to emphasize that there are no biases or harmful trends in over screening populations thought to be at potentially greater risk due to incorrect information or stereotypes, and that the implementation of screening or systematic identification practices really consider everyone and be evidence informed. And I've already talked about, the real opportunity for forensic evaluations, particularly when crimes carry a serious amount of risk, where there's been a really significant harm and the legal decisions are complex. We think that there needs to be policy-based continued effort towards FASD specific training and education for criminal legal professionals and also forensic clinicians that is debiasing and addresses stigma. We heard a little bit of some of the language today and some of the legal decisions, and recognize that as professionals, we're learning a lot every day about how to share information and communicate in ways that are responsible, ethical, and respectful and don't further negative stereotypes or stigma. And the Canada FASD Research Network actually has a great open open access common language guide that helps give all the do's and don'ts of ways that we've learned to really talk about the experience and needs of people with FASD so that we're not inadvertently perpetuating some of those harmful stereotypes. And that this training should include cultural considerations that are relevant to FASD and include the impact of colonial and assimilationist policies on in all kinds of common law jurisdictions, the over incarceration of Indigenous individuals and also other folks as a result of systemic racism across time and Canada for sure. In addition to increased understanding and training, there's a clear need for improved supports and services with an increased focus on resources available in both community and legal contexts, taking into mind the unique considerations of people with FASD who find themselves before the courts. There are several really exciting and innovative projects and programs emerging that take a therapeutic justice and restorative justice approach. There are problem-solving courts like the Manitoba FASD Court Docket and all kinds of specialized legal person-centered FASD assessment programs, including the Manitoba Youth Justice Program, the FASD pilot project that ran through the Federal Regional Psychiatric Center, and others. But importantly, research is really needed to ensure evaluation and that outcomes are effective using a holistic lens, so that when we pilot these projects, we really understand if they are helping produce the kinds of outcomes that are in the service of justice and improved outcomes for people with FASD and also for the community and for folks who have experienced victimization and harm. And that these programs ideally are going to emphasize a different definition of management over sort of traditional definitions of treatment, and really look at outcome factors beyond just reduced recidivism. And I think zooming out, there's a really important and clear continued need for improved evidence so that the kinds of policy program and funding and practice decisions we're making are evidence informed, particularly as we continue to consider FASD informed legal changes and policies. And I think a diverse range of research methods are really needed to understand how FASD evidence impacts legal decision making and outcomes. Being able to look at the reported public written reasons for decisions is different than really being able to engage with and understand a legal decision maker's rationale and considering and weighing of different kinds of case factors. And there are all kinds of methods that we can use collaboratively to really understand what the needs are of the judiciary and the bench of Crown and Defense Counsel and so on and so forth to help make evidence-informed policy recommendations. And ultimately, given our findings, and Jonathan is going to speak a little bit more about those, evaluations and research that look at the intersection of FASD, indigeneity, and the criminal legal system really need to be situated using culturally specific frameworks, look at those systemic inequities and impacts of policy, and be led by or conducted in collaboration with experts and Indigenous scholars and community agencies using appropriate research methods and research approaches. We think that's a really important next step for this line of research. I see some Q&A in the chat that we'll get to, but I just wanted to let you know. Oh, there's one more slide before I let you know. I'll be really quick. Go ahead, Caitlin. Yeah, we can go to the next one. We think these results generalize best to the Canadian legal jurisdiction, of course, because considerations around sentencing and common law are rooted in our national criminal code, but that we've observed and read about, and I'm sure those attending today have experienced similar kinds of barriers and tensions regarding FASD in the criminal legal system in other countries like the United States, New Zealand, Australia, the UK, and those who share similar common law criminal legal systems. There are some other limitations. Jonathan will speak about a few I've mentioned that focusing only on reported decisions kind of covers a small snapshot of the kinds of cases that are actually decided every day in court. And our focus for the purpose of this analysis on great relevance cases allowed us to take a really deep and rich examination around the cases where a justice had taken the time and really weighed consideration of evidence about FASD in relation to legal decision making and key case outcomes. But that doesn't capture the full breadth of the kinds of cases where evidence about FASD was mentioned. And so the database that we've gathered is a really rich and living resource. And if we can't answer your questions today about specific cases because there were so many, feel free to get in touch with us, because our hope is to be able to continue to update this database and to be able to collaborate on research so that we can really understand different kinds of key issues that we weren't able to focus on in this first analysis of the data. So I think that's it for me. And if I'm on track, now I'm going to turn it over to Jonathan to help sum up some of the unique findings and limitations of our paper and put things into context.
Thanks very much, Caitlin's. So I wanted to look at some of this information in both a deeper way, but also acknowledging that there are many things we don't have answers to. And what's very interesting about this research is it gives us some very concrete data, which is very important to have. But at the same time, we have to be very careful about drawing conclusions from that data, because we can be led to some very erroneous conclusions. And I want to focus particularly on two sets of data that you saw at the beginning. And the first is about the percentage of cases that we saw. So you'll see here in this slide that 77% of the reported cases came from BC, Alberta, Saskatchewan, Manitoba, and the Yukon. So that's 77% of reported cases, representing just over 30% of the population. Now that doesn't, there needs to be an explanation for that, but it can't be, or doesn't make any sense, that FASD only occurs in, or primarily occurs in, these provinces. And for example, there are hardly any cases of FASD in Quebec or the Maritimes, which is, if you look at the map that Caitlin showed at the beginning, that's what it would suggest. So something else is going on here, and we can't be definitive about what that something else is, although I'm going to advance a couple of hypotheses. But we have to be careful not to assume that this is where FASD is necessarily occurring more frequently. And this brings me to the next slide. And this is like, I mean, it's crazy. These numbers are crazy. They don't make any sense. And I don't mean that they don't make any sense in terms of what the research shows. This is exactly what the research shows, and is continually shown this. But the idea that 77% of those people who are involved in the criminal justice system who are identified as perhaps having FASD are Indigenous, that also would be the wrong assumption to draw. In fact, the percentage is even higher if you take the not noted out. Then 99% or 98% of those people are Indigenous, and 2% would be white. Again, that cannot be the case. And it's important to start this by understanding where Caitlin McLaughlin began, that in terms of FASD prevalence rates, we don't actually have a firm sense of prevalence rates of FASD in Canada. We don't know. And so what's happening is the willingness for certain people or certain groups of people to consider FASD, the social stigma attached to FASD, means that we see it more in some populations than others. But it would be wrong to assume that FASD only occurs in Indigenous populations, and only Indigenous people who are in conflict with the law are impacted by FASD. Again, that doesn't make any sense. So what does this data show? What are some other alternate explanations? And these are alternate, we don't know for sure, to pick up on the issue, the need for more research. We can't know these things for certain. But we know that in Canada, Western provinces have been much further ahead in recognizing FASD as a factor to consider in sentencing. And so the Yukon, some of the first FASD decisions in Canada came from the Yukon. That knowledge went down to British Columbia. One of the reasons that we see more of these sorts of decisions from the West is that many Indigenous communities have been very open and willing to address concerns about FASD. And so, given the overrepresentation of Indigenous people generally before the courts, in some ways, it's not surprising to see that there's a disproportionate number of Indigenous people before the courts where FASD is suspected. We know that Indigenous people are overrepresentation is the wrong, I don't use that word anymore. We know that Indigenous people face mass incarceration in Canada. We know that 30% or more of people in prison are Indigenous. We know that people who, and from one of the earlier slides, people who are affected by FASD are more likely to become involved in the justice system. So if you put those two things together, it will not be surprising that there will be some overrepresentation of Indigenous people beyond the overrepresentation that they normally face in the criminal justice system. So that's not surprising. But there are other more difficult issues to tease out. When you look at the data, one of the things that it describes is the fact that in many cases FASD is mentioned. So defense counsel might say, well, I think maybe my client may be affected by FASD, but there isn't a diagnosis, and there may not be a diagnosis for any number of reasons, but largely, as was pointed out, it's very difficult to get a diagnosis, particularly if you're an adult. And so often defense counsel are left saying, well, I don't know, but I think maybe this person has FASD. And some of that is tied to whether we use the term a willingness or a bias to assume that Indigenous people are more likely to be exposed to FASD. And counsel may be more willing to say that for an Indigenous person than they might for a non-Indigenous person, because we need to recognize still that, unfortunately, there is stigma associated with FASD, and that stigma is not just on the individual who is affected by FASD, but by their parent and particularly by their mother. And so counsel may be unwilling to make certain generalizations or assumptions if, for example, the person is not Indigenous. So these are all factors that may be at play when we think about why we see the numbers that we see. Because, as I said, it can't be that the only people who are affected by FASD before the courts are Indigenous. There are other issues that I just want to touch on because I see there are a number of questions and we want to have time for a number of them if we can get to them. But I want to talk a bit about the issue about not criminally responsible that Caitlin Mullally pointed out. This is a very specific issue that is very much tied to the Yukon. At least my understanding is it's very much tied to the Yukon. Forensic psychiatrists, who usually are required to assist with not criminally responsible diagnosis, are not necessarily well equipped to deal with fetal alcohol spectrum disorder. And so they're not always great at picking that up. At the same time, a lot of lawyers are reluctant to rely on a not criminally responsible or mental disorder defense for their client because it may mean that they do more time in jail than they might otherwise do. And in fact, while Indigenous people are overrepresented in all aspects of the criminal justice system, they're actually underrepresented among those who are found to be not criminally responsible. One of those concerns, of course, is if, and this gets into the rehabilitation treatment issue, there's a concern that if your client is found to be not criminally responsible because they have FASD, that FASD will never be cured. Also, problematically, for trying to advance a not criminally responsible defense, many people with FASD, most people with FASD, know what they are doing and often know what they are doing is wrong. They just have difficulty controlling their impulses and their emotions at a particular point in time. And because of that, they generally don't tend to qualify under the rubric of NCR in Canada. Now, the reason that there's this exception for the Yukon, or at least there was, because these are not the most recent decisions. The Yukon had a very well-developed approach to individuals with fetal alcohol spectrum disorder. And at least anecdotally, what I have been told is that individuals who are found not criminally responsible, who also had FASD, although they went into the NCR system and into a secure forensic psychiatric facility, were not there very long before they were found to be suitable for admission into the community where they could be looked after. And that probably explains more than any sort of detailed legal explanation why we see these two cases. And what that speaks to more generally is the fact, as Caitlin McLaughlin pointed out, that a lot of these developments in terms of case law are specific to particular courts, sometimes particular judges, particular counsel, who have an understanding of these issues and have arrived at accommodation sometimes within the court system where there is an awareness that everyone in the room has a better sense of what FASD might mean, and people are not necessarily as perhaps reluctant to raise it in certain contexts because they think that there is a shared understanding of what an FASD diagnosis might mean, or an assumption or a thought that someone might be affected by FASD. So all of these areas are fascinating areas for further explanation. They are not going to turn up by way of this sort of case analysis, which is not to say we shouldn't continue to do this case analysis, because I think it's very important and very rewarding. But it speaks to the need for other types of research, research where people are sitting in court, follow a case to its conclusion. So for example, researcher looks at 2 or 3 cases and follows them through and sees what language is used at all stages during the case, what submissions are made by counsel. None of that comes up in these reported cases, because all you have at the end of the day in the reported case is what a judge actually concludes. And so we don't have this other very rich but difficult to obtain data. And those of you who are looking for research projects, that would be a very interesting studies to undertake. So there's still a lot of work to do here. There is, and my final point, and then we'll go to the questions. So I see there are a lot of them. I just want to speak briefly about the attempts to try and amend the criminal code. There have been a couple attempts to amend the criminal code in Canada to explicitly make FASD a mitigating factor in sentencing, to try and avoid the dual nature of some of the impacts of an FASD assessment. And these have foundered eventually, because the concern that was raised was that to mention FASD specifically as a mitigating factor, as opposed to other things like traumatic brain injury or other things, would be to preference a particular medical condition, and that would not be right, or would challenge the way our criminal justice system works. That's a discussion for another day, but those discussions do need to happen. So I'm happy to stop at this point, turn it over to Carol, and we'll get to as many questions as we can. Thank you.
Thank you, Jonathan and Caitlin's. Thank you for a great presentation. And we do have some really good questions that have come in, and I'm just going to go through them as they appeared. I think, Jonathan, you probably touched on one already, but the first question that comes in is, were there any rehabilitation plans found to be particularly effective in the cases that you reviewed? Did you have a note of that? Caitlin's.
Caitlin, can you miraculously think of one off the top of your head?
Well, so I guess what I was thinking in response to this, I think this is sort of one of like the ultimate questions, right? That I think arise from the data is that there were some in a very small number of cases. I mean, there was debate over rehabilitation itself, right? And whether it was possible or what might be a good fit, and some suggestions, but very few. And I think unfortunately we didn't have the data, right? In these cases, we could sort of look at what the judge's decision was or recommendation was, and that was the extent of the data that we have. So I think my thought was this, and I think this is one of the areas that's currently receiving a lot of attention, right? And there's lots of calls for more research in this area to better understand sort of rehabilitative needs of individuals with FASD more generally. Yeah, go
So
ahead, Jonathan.
one case that is interesting, but it speaks to the challenges, is a case of Drysdale, which I think is referenced in the book, in the article. Drysdale is a decision from the Saskatchewan Court of Queen's Bench from 2016. But the sentencing hearing in Drysdale took 3 days. Like, there were 3 days spent calling witnesses to speak about sentencing. And Mr. Drysdale, in this case, pulled a knife on someone, and there were very serious concerns about public safety. But the court system itself is not well equipped to spend 3 days on a sentencing. Now, this mattered to Mr. Drysdale, who did not end up going to jail. But this is, I think, the other issue around the rehabilitation issue is, how do you present that information? The other thing that is part and parcel of this, but also difficult to address, is the ability of individuals to get bail, because the option of getting a rehabilitative sentence, if you've been spending all the time in custody and remand, it's very hard to argue that when you're released, you're going to be okay because these things are in place, because the judge will think, well, is that really going to work? We haven't seen it. And there has not been an opportunity to provide sort of a track record of the person's the way they've worked under some form of supervision outside of custody. End of it.
I think
We can go to the next. Caitlin.
Okay.
I think that sums things up. I think because we don't have the case plans, we get really high level information, and there really was a lot of debate and consideration in some cases around whether programming offered in a longer federal sentence was going to be more rehabilitative than shorter programming due to lack of availability. So this was an important tension. And certainly folks who have interest and are looking for particular cases are welcome to get in touch with us. We've listed them all and they're all coded. So that makes it actually pretty easy to look up key themes if folks have questions.
Yeah.
Sorry, I got one more thing. Sorry, Carol Lee. I had to, this issue about programming in prison is a real challenge, because no one really understands programming in prison, at least including people in prison. But judges and lawyers don't. And so there will sometimes be experts from Correctional Services Canada who will talk about all these great programs we have. But it's not clear that that programming is actually equipped to work with someone who may have the cognitive deficits that someone may have with FASD. And so we have to be careful about counsel have to be careful not saying, oh, yes, I think this is a good idea that the person go to jail for X period of time because they're going to get all sorts of programs, when certainly a couple of the cases that are discussed in the article, individuals have been in the penitentiary for a long period of time and have not had access to programming, even when it was determined they had FASD. Okay, but now I'll stop.
Okay, so I'm going to go on to the next question, which is also drilling down into the maybe what was in the cases and the reports. But This is, were there particular characteristics of the individual's FASD that judges highlighted in their sentencing decisions, for example, impulsivity, or did they typically refer to FASD more broadly? So I guess, what did you see in the decisions in terms of that kind of specificity? If you're able to answer that.
Okay, I'll
I'm not
start.
sure, Caitlin, if you're. Oh, go
Okay,
ahead, John.
so this issue of impulsivity is an important one, and I think, and this is something that is coming up in a number of contexts. Someone have a diagnosis of FASD, but if it looks like they have planned something, it somehow makes it seem like the FASD never mattered. There's a tendency for judges to, once they see, oh, there was an element of planning. This wasn't just this immediate impulsive thing. You went home, you got a gun, you enlisted a friend, you got a bat, doing these things. All of those things judges will often interpret as militating against the impacts of FASD because it looks like you knew what you were doing and you were planning. And so that certainly is, we've seen that in a number of cases, even where there's an FASD diagnosis.
Caitlin, did you want to add to that?
I think from the perspective of like the cases itself that we looked at, this is where we saw a fair bit of variability, right? That in about half of the cases, there really was just like very like brief mention of FASD, sort of in passing and discussing the defendant's background and moving on. And it was really just a subset of those great relevance cases, particularly I think the ones where there was a formal assessment that had been done, where we saw them sort of diving into more like the challenges, right, or characteristics of the defendant's strengths and challenges, right, and those comments I think from judges as well, saying like we are limited in our ability to really draw conclusions about the link between FASD and the sort of offending behavior, the behavior that we're seeing without having these formal assessments, right? Which, as Caitlin noted, is one of, I think, the huge challenges in these cases. So I think that's all to say there was just that really small number where it was mentioned in more detail, where there did happen to be an assessment where we saw further discussion of that.
Okay. So are there certain characteristics, whoops, there we go, commonly associated with FASD that legal professionals could identify and highlight that are less stigmatizing and could help inform legal decision making?
I think that question might have come from Bianca. It's nice to see you, Bianca, someone who helped on this project in paper, and great question, of course. There is movement towards being able to better recognize signs and cues that somebody could have FASD, not only because that might inform decision-making around whether there's a need for a more comprehensive assessment, depending on the nature of the circumstance and the kinds of decisions being made and interventions that may be needed, but also because recognizing that somebody may have FASD allows everyone involved in the adjudicative process to change the way they interact with somebody right then and there. So it could mean somebody, and I'm not going to go into a fulsome list because I've got a recommendation to make. It could mean somebody having really complex, repeated patterns of involvement in the criminal legal system with lots of charges and sanctions for not adhering to conditions. Certainly, if there's a flag that there may have been PAE, there's a biological sibling who has FASD, and other kinds of cues, somebody who seems to have trouble sort of understanding things when you ask them to paraphrase what's going on, who misses appointments and needs lots of reminders, lots of those cues. Our team is also, as you know, and as you contributed to, really been involved in creating screening tools and toolkits that can help legal professionals in particular and other professionals recognize who may have FASD and then change and respond right in that moment in a more FASD informed way. And sometime later this year in 2024, we're going to also be piloting a toolkit that's specifically designed to help recognize people with FASD across a range of criminal legal contexts. that combines both everyday strategies for being able to recognize and identify those cues and respond in really person-centered and appropriate ways, depending on folks' roles, as well as a new FASD screening tool. And that's a project being conducted in collaboration with researchers across Canada, at the University of Alberta, and the University of Saskatchewan, the Asante Center, and supported by the BC Law Foundation. So we're really excited to be rolling that out, and hope that increasing knowledge and awareness, recognition of those cues can help inform immediate responses, and also more evidence-supported approaches to next steps.
And can I say that how important that is? Because in the court system, it's often people don't have much time, and you are what you present. Daniel Kahneman, in his book Thinking Slow and Fast, or Thinking Fast and Slow, whichever it is, has a term that I think it's what you see is all there is the term. And in court, what you see is all there is. That's how the court works. If you're 25 and you stand up in court and you look like you're 25 and you speak like you're 25, even though you may say very little, everyone assumes you're 25. Like, no one's going to stop and no one's going to ask any questions. And your lawyer, who you may or may not spend much time with, will make the same assumptions. And so this becomes really crucial, is it for people with FASD where there has not been a diagnosis or no one's brought it to the legal professional's attention, they can just zoom right through the system and no one will ever know. And they'll keep coming back. And judges will get frustrated. Why are you back here again? You're not listening. You don't care. All that stuff. And we will lose the ability to share the important information. So I think this work, Caitlin, is really important. And the sooner the better. Why are you wasting your time? Not wasting time. Why are you here? Why aren't you doing this? Come on.
So the next question, is, what role did substance abuse play in the original criminal charge? And this, the person asking this question said, this is a particular layer we see in the majority of our cases. How does that impact the decision if it is from first substance and second the diagnosis of FASD, or the reverse? Yeah.
That's a great question, and something I didn't highlight so much today in talking about our results is that while FASD was often very clearly mentioned, right, and explicitly discussed in the context of these legal considerations, it often wasn't discussed on its own, right? There were often other sort of individual considerations relevant to that defendant that were discussed in tandem or in the decision as well. So I think I highlighted one case where there was mention of the combination, right, of FASD as well as a learning disability and substance use in how that defendant was perceived by the court, or at least how the decision came about. We didn't code so much, so we did code in our data for any other diagnoses, and then whether there was mention or history of other substance use difficulties. So we certainly have that data, at least to look at whether that was relevant or mentioned in the context of the defendant. But I think that is really important, right? That often FASD isn't going to come up sort of in a silo, right? It's going to be discussed amongst and considered amongst other things. And I think that was a bit of a challenge, right, in sort of drawing conclusions, is that we were able to say in some cases where there was a clear link how FASD was considered. But again, that FASD often wasn't the only thing sort of contributing to the ultimate decisions or considerations mentioned.
Okay, so
anything that you'd add?
Does either of you want to add to that? No, okay. So we'll try and get to a couple more. And the next one is, what about FASD being considered at the beginning stages of a case rather than just at sentencing? And I know you didn't see, the research doesn't comment a lot on that, but the question is there precedence in case law about that? And the comment being, FASD could possibly lead to a reduction or dropping of criminal charges due to the mental age capacity of the offender.
So let me say that it's not just, it goes even before that. There's question of confessions, and as Caitlin Mullally showed going through the data, there's not a lot of cases about this. One of the things that's very difficult is that someone gets arrested, they may give a statement. The cautions in Canada, there have been studies that show that when someone's arrested, the police read a caution. If you have FASD, the caution will make, I mean, if you don't have FASD, the caution often makes no sense. But if you do have FASD in the context of being arrested, the caution makes no sense. People are inclined to make statements that are against their interest that may not even be correct because they want to get out of the place they're in. The most notorious case is the Pora case and those of watching from New Zealand will know this case very well, where a young man confessed to a murder that he did not commit and was in jail for many, many years until he was diagnosed with FASD, and the Judicial Committee of the Privy Council, which is a legal arcane body that I won't bother with anymore. But anyway, in England, ordered him a new trial for him. But again, it requires counsel to know, it requires diagnoses, it requires a lot of things that we often don't have. But there's no question, if you do have that information early on, it can help in plea negotiations. But often that process there's a lot of pressure on people to get things worked out early, especially if someone is denied bail. Again, why bail is so important. If the charges aren't incredibly serious, someone doesn't want to wait for a long time for an assessment if you can even get one. So all those things factor in. It is clearly a really important issue, but it's unfortunate that the way the criminal justice system works often works against that, and sometimes means that FASD really only gets considered at the back end of the process.
Okay, and I'm just going to get to one more, I think, because of our time. But there's a question about pilot programs or existing programs that might be operating in Canadian correctional centers. In my experience in the jails, FASD is extremely misunderstood, leading clients to receive many more institutional infractions, warnings, conflicts, and segregation time. Do you want to comment on that?
Oh, I can comment quickly. As part of the research phase of the screening tool development, our colleague Megan Sherman at the Asante Center led a review, environmental scan of all sort of programs in British Columbia tailored for people with FASD and criminal legal system involvement. And then as part of that review, looked at promising and pilot programs all across Canada operating within and outside correctional environments. And that scan is available online. I can't remember where off the top of my head. So definitely send me an email if you're interested in having a look at that. It's probably on the Asante Center website, and was just recently wrapped up. And there's also a research wrap up from that project that includes a link to that on the Canada FAC Research Network website. And we really were able to get in touch with all kinds of neat program folks from programs running all kinds of interesting and innovative programs looking at how to better support and understand people with FASD. So that would be a resource that could help answer that question. That's hot off the presses.
Great. Thank you all so much. This was great. And thank you for a great discussion, your insightful comments and questions, and for this great and thoughtful and balanced and important research. I remind everyone that the recording of our session and the slides are going to be posted to fasdjustice.ca. They'll be up within the week, so it'll be available to anyone who wants to watch it. It's a public site. There are also multiple resources there, recordings of our 2 previous webinars. There's a short video, which is our recent project called Try to Imagine, about what it's like to have FASD. There's an extensive case law section, which we try to keep updated. So please use it and please tell people about it. And watch for the announcement that's coming of our next webinar, which will most likely be in April. And we're going to talk about the Truth and Reconciliation Commission calls to action that talk specifically about FASD. Now, we've posted a link to a short survey about today's webinar, which I've posted in the chat. It's very, very short. just a few questions. It'll just take minutes to complete. It's just very helpful for us to hear about whether this has been helpful for you, and it really informs what we do next. We'd like to thank the Canadian Bar Association for providing the funding support for this webinar through the Law for the Future Fund. Thank you to Mitch Gibson and to Impact AV Solutions for your help in delivering our program today. And finally, thanks to all of you who signed on to join us. And now we'll sign off. Goodbye, everyone. Stay safe.
Thank you.